So historically, casual workers or employees have been employed by employers to work irregular hours of work on a weekly basis. So casual employees historically have had a very informal arrangement with the employer, where the employer basically provides a roster each week according to the needs of that employer, and the hours will generally vary week by week.
Okay.
Well, currently the percentage is approximately 25%. So 25% of the workforce are casual employees, but the case that we're going to talk about may have an impact on that percentage and possibly mean there may be a decline. Interestingly and not surprisingly, the hospitality industry is made up of 65% of casuals. And then following that is the retail industry, as well as the agricultural, fishing and mining industry, which has approximately 40% of its workforce as casuals.
Right.
It's too early to tell. Over the past decade, it's been reasonably the same. But again, this 2018 case of WorkPac and scheme may have an impact on that percentage and possibly mean a decline.
So what's the reason for the uncertainty?
Basically, the case of WorkPac and scheme highlighted the fact that even if you have a contract which is written and specifies that there is an employment deemed one of casual employment, it doesn't actually mean that the casual employee who signed the written contract is in fact working as a casual employee and therefore entitled to casual employee benefits. Basically, the court in that case looked at the pattern of work and also the hours that that employee was undertaking on a weekly, monthly and yearly basis, and worked out that in fact, even though that employee was classified as a casual and it was written in the contract as such, the hours weren't irregular, they weren't uncertain, they weren't unpredictable. In fact, he had a very regular pattern of work, and therefore the court found that he was in fact a permanent employee.
Okay.
Yes, well, Paul Scheme was a labour hire employee, and he was employed by WorkPac, which is a labour hire employer, to work as a dump truck operator at a mining company in Queensland between 2010 and 2012. He was given a notice of offer of casual employment in a written format, which required him to work 7 days on and 7 days off at a rate of $50 per hour. He also was required to fly in, fly out, and he was requested to remain at that work site each week and then leave and then fly in for the following week. He claimed that he was not a casual employee. He claimed he was entitled to be paid permanent employee entitlements based on the fact that his system of work was not informal. He stated that he had been given a roster that was one of a predetermined plan that was had a regular set of hours. The federal court made a decision that Scheme was in fact a permanent employee, and in doing so they looked at the true nature of the relationship and the practical working reality between the employer and the employee. They looked at the fact that Scheme was given a roster which had a pattern of set hours, and that pattern continued week by week. It was certain and it was systematic. They also confirmed the fact, which was important, that the roster was given 6 months in advance, So it's a predetermined roster. And as a result, he had an expectation that the work was continuing for, a definite period of time. And they said that that was consistent with one of a permanent employee. So basically the court, in making a decision that he should be classified as a permanent employee during the duration of this employment, confirmed that he should receive the annual leave entitlements that he was claiming. And so a decision has been made to award him those annual leave entitlements. If a court makes a finding that a person who's been working as a casual worker is in fact a permanent employee, the employer then is required to pay out a number of entitlements, including annual leave, sick leave, compassionate leave, parental leave, redundancy pay, and also public holidays. So this can have quite an impact on the employer. And according to the Fair Work Act, the employee has the opportunity to claim entitlements as far back as 6 years. So this can be very costly for the employer. So therefore, it is important that the employer from the outset examines how they engage the casual employee. If they wish to have a casual employee, that it is important for that employer to make sure that the hours of work are irregular and informal, and that casual employee is employed on a weekly or fortnightly basis. If an employer is going to put a casual employee on a predetermined roster for some months, then they're going to run into problems with the court. So if that is the case, then they're going to have to consider, well, is this really the true nature of a casual? Yes, this is a new provision under some of the modern awards, where those modern awards will allow an employee to make a request to an employer after the employee has been working for that employer for 12 months, that their position be converted from a casual employee position to an employer position. However, that request must come based on the fact that that employee is in fact working hours that can be classified as hours according to those of a permanent employee. And as I've indicated before, that really relates to the hours being certain, predictable and regular.